está haciendo la mayoría. Boten la basura afuera, por favor, no lo dejen sucio dentro del salón para asegurarnos de que todo esté limpio. Y si quieren utilizar interpretación simultánea para español, inglés, dependiendo del idioma en el que ellos estén hablando, lo único que tienen que hacer es escanear el código QR que tienen enfrente de ustedes, muchos de ustedes. Asegúrense de tener audífonos también conectados a su teléfono y así se benefician de la interpretación simultánea. So I'm going to be now speaking only in English from this moment for the rest of the panel. So I'm going to switch now to Professor Diego Rodríguez-Pinzón, who is the moderator of the event. Professor Diego Rodríguez-Pinzón is a co-director and professional lecturer in resident at the Academy on Human Rights and Humanitarian Law at American University Washington College of Law, where he also co-directs the LLM in Human Rights and Humanitarian Law. He holds an LLM from this law school and a doctorate in judicial science, SJD, from George Washington University. He served as a member and rapporteur of the United Nations Committee Against Torture and as an ad hoc judge of the Inter-American Court on Human Rights. He has also worked at the Inter-American Commission on Human Rights and taught in leading institutions around the world, including France, the UK, Belgium, China, and Latin America. Professor Rodríguez-Pinzón is the author of numerous publications on international law and Inter-American human rights law and continues to be a key voice in these fields. And it's also my boss, so I hope I did it right. So Professor Pinzón, it's your turn. Okay.
My voice.
Gabriel, thank you very much for the introduction, and welcome everyone. Welcome to our first panel. Here we are opening the Human Rights Month for this year, 2025. We are delighted to have you all. As many of you know, in the past, we have had this forum of discussion as a great opportunity for all of you to get to know our faculty that are coming from around the world, and we are delighted to have you all here in this panel and hopefully engage in some of the most important discussions of our time. And nothing more important, I believe, than talking about global governance and multilateralism in these times. You know, we always feel we are in times of crisis every year. I remember when we began 26 years ago, the first Human Rights Month, we were talking about we are in a time of crisis. So I think to a certain extent, international human rights law works in this framework, works in times of crisis. Some say these mechanisms thrive in times of crisis. I think maybe that's too much, but to a certain extent, I do believe that human rights mechanisms, human rights advocates, human rights academia, all of those that are engaged in these conversations in international human rights law are indeed immersed in very difficult contexts, regional contexts, national contexts, and that international human rights mechanisms are a reflection of what we see in the national level in many instances. I will leave it there so we can begin hearing from our panelists. We are delighted. I'm going to be presenting each one of the panelists as they speak. Probably I'll give you some heads up when we are getting close to the 10 minutes. You can take a little bit more if necessary, and that will work just fine. And at the end of the presentations, we'll open for some Q&A, some questions and answers from you all. Again, thank you very much for being here. And we're going to follow this order. We'll begin with a presentation from my colleague, Professor Laurence Burgorgue-Larsen. I destroyed your name. I'm absolutely sure. Professor Burgorgue-Larsen is professor of law at the Sorbonne Law School in University Paris I, member and former vice deputy of the Research Institute on International and European Studies in the Sorbonne. She's also was director of the Studies Group on International Law and Latin American Law, and director of the Masters to Human Rights and the European Union in that institution. She is the director of the collection Cashier Européens, you have to tell me, in the French publisher Pardon, and member of numerous advocacy advisory boards on, and among others, the advisory board of the legal journals in the European Journal of International Law and others. Between 2012 and 2019, she was member of the Constitutional Court of Andorra and was president of this mechanism between 2014 and 2016. She carries out academic research, and teaches in the areas of human rights law, comparative constitutional law, and European and international law. Her publications in 3 languages are diverse in the field of regional human rights law. Recently, her book, The 3 Regional Human Rights Courts in Context, received in 2024, received an award by the American branch of International Law Association in October of that year as the American Bar International Law Association Book Award of the Year. There is also a French edition in Paris, and also a Spanish edition in the editorial, Mexican editorial Porrua. I will leave it with that. Please, you have the floor, Laurence.
Thank you so much, Jim.
Let me move it here.
Genial, gracias por la linda presentación, gracias sobre todo por la invitación. Soy súper feliz de estar aquí de nuevo y de poder compartir unas cuantas ideas con vosotros, los de la mesa y los, claro, de la aula. Voy a dividir unas cuantas pequeñas ideas en 2 partes. Soy francesa y en Francia adoramos. Es un poco preocupante este Larsen. Es mi nombre, Larsen. Es mi marido que está aquí y que me dice, cállate.
No, it's acá. I think it's yours.
¿Qué pasa?
Gloria, I think you're sitting.
Ah,
Oh, that's all right.
no, continúa. Ah, no. It's very strange. There are some spirits in the room. Ok, entonces voy a dividir mi presentación en 2 ideas. En Francia somos como totalmente arraigados a esta visión binaria de la realidad, pero es más fácil a veces para presentar. Creo que el mundo contemporáneo y las organizaciones internacionales están enfrentadas, y más particularmente las cortes regionales, a un doble desafío de legitimidad y de eficacia. En cuanto a la legitimidad, y voy a enfocar mis ejemplos en el sistema europeo porque el tiempo que tengo no es demasiado importante. En cuanto a la legitimidad hoy en día del Consejo de Europa como de la Corte Europea de Derechos Humanos, esta legitimidad está contestada de 2 maneras. Una contestación por arriba, por los estados que se ligan y que presenta de manera común su ira en contra del sistema como tal de protección, y una contestación desde abajo que viene de los estados cada uno, tomado en cuenta. Eso es la legitimidad, el desafío de la legitimidad. El desafío de la eficacia le voy a presentar en unos cuantos minutos, pero para presentar la idea clave aquí, la eficacia del sistema de protección europeo hoy en día es totalmente limitada. Es limitada de manera existencial. La eficacia política hoy en día Europa es muy limitada y le voy a explicar. Y la eficacia que yo he llamado, para encontrar una idea más precisa, técnica, la eficacia que tiene que ver con la implementación como tal, es también muy limitada. Y estos 2 desafíos de la eficacia es existencial. Entonces, si tomamos la primera idea de la legitimidad. Cómo los estados contestan la legitimidad tanto del Consejo de Europa como de la Corte desde arriba. Muy sencillo. Fíjense que el 22 de mayo de 2025, por primera vez en la historia del sistema europeo, a raíz de una iniciativa de Dinamarca e Italia, 9 presidentes y primeros ministros firmaron una carta oficial sumamente singular. Por un lado, afirman el hecho de compartir valores comunes, el Estado de Derecho, los derechos humanos, recuerdan que están involucrados en la defensa de un orden internacional fundado en el derecho. Muy bien, pero inmediatamente, por el otro lado, afirman compartir un importante involucramiento para sus respectivos países una gran responsabilidad para sus sociedades y entonces consideran que quoto, es decir, quoto las palabras, el tiempo, sí, cito, perdón, quoto, el tiempo, mezcla de idiomas. El tiempo ha venido a discutir la manera con la cual los convenios internacionales abordan los retos contemporáneos, afirmando que lo que ha sido justo un día, es decir, al salir de la Segunda Guerra Mundial, puede no ser la buena respuesta hoy en día y para el futuro. O sea, de repente es el tema migratorio que está puesto a la luz en la Carta Común, diciendo que, por un lado, hay extranjeros fantásticos que vienen de manera legal y que se insertan en las sociedades europeas, que lo hacen bien, que comparten los valores democráticos y que trabajan y que por eso aportan mucho a las sociedades europeas. Y de inmediato la carta dice, sí, pero hay otros migrantes que vienen de manera irregular, que no viven en la sociedad, no aceptan los valores comunes, viven en comunidades aisladas y sobre todo, añade la carta, a veces cometen crímenes. Y eso los presentes, estos nuevas personas dicen, eso no es admisible, tenemos que proteger a nuestros ciudadanos que lo necesitan y lo reclaman. Estos estados son unos cuantos del oeste de Europa, Austria, Dinamarca, Italia, Bélgica, otros de Europa del Este, Estonia, Polonia, República Checa, Letonia, Lituania. Se felicitan que hoy en día la Unión Europea va a cambiar las reglas para hacer más difíciles para los migrantes y requieren de la Corte Europea un cambio radical de interpretación de la regla del Convenio Europeo para con los migrantes y sobre todo para los migrantes que vienen de manera ilegal, pidiendo a la Corte Europea que deja a los estados manejar de manera soberana sus fronteras. Y la carta termina diciendo esto, in English. In Her Majesty, we believe that we are strongly aligned with the majority of the citizens of Europe in our approach. We want to use our democratic mandate to launch a new and open-minded conversation about the interpretation of the European Convention on Human Rights. We have to restore the right balance, and our countries will cooperate to further this ambition. La paradoja suprema es que todos los analistas del sistema europeo saben que la Corte Europea ha totalmente, desde aproximadamente 15 años, cambiado poco a poco su jurisprudencia para ser más diferente con los estados, poniendo a la luz más y más la soberanía, el sistema democrático de los estados, el margen nacional de apreciación. Entonces, estamos en un momento loco en el cual políticamente se acusa a la Corte Europea y en el mismo tiempo sabemos todos que desde mucho tiempo ella es mucho más diferente con los estados. Bueno, y ha desarrollado un montón de técnicas de interpretación como el process-based review o el judicial-based review para dejar mucho más margen nacional de apreciación a los estados. Eso es la contestación por arriba. Hay la contestación por abajo. Cada estado del Consejo de Europa contestan más y más. La legitimidad, la autoridad de las sentencias de la Corte Europea. Y el ejemplo francés es asombrador. El primer ministro actual ha considerado, a raíz del asesinato de una joven estudiante francesa por un migrante que estaba en situación ilegal, un crimen que ha sido, claro, instrumentalizado por los medios de comunicación, que ha generado mucha emoción en el país. El primer ministro francés ha dicho, el Estado de Derecho no es intangible y no es sagrado, acusando exactamente como los 9 estados, acusando a la Corte Europea de imponer a los estados reglas que no caben con la mayoría y la voluntad popular de Francia. El propio ministro del Interior ya no ha aceptado implementar medidas provisionales ordenadas por la Corte Europea, pidiendo que se pare la ejecución de una decisión de expulsión para que la Corte Europea pueda examinar el fondo del tema. El ministro del Interior ha dicho no respetó la decisión de medida provisional de la Corte Europea porque el ciudadano que queremos expulsar es un ciudadano de Uzbekistán, musulmano radicalizado, y no queremos que continúe a matar a franceses. Bueno, todo esto es muy preocupante porque esta contestación que viene también de arriba por los políticos está sostenido en Francia y en toda Europa por grupos conservadores de intelectuales muy influyentes que usan de los medios de comunicación de todo tipo para generar esta narrativa muy negativa. Como el European Center of Law and Justice, I will explain maybe after. Segunda idea, una eficacia limitada, y iré muy rápidamente. Eficacia política e eficacia técnica sumamente limitada. La eficacia política del Consejo de Europa hoy en día está en tela de juicio. ¿Por qué? Porque también hay que hacer la crítica de las organizaciones internacionales. El Consejo de Europa ha expulsado a Rusia, lo sabemos todos, en 2022. Pero durante años y años, el Consejo de Estado no hizo nada de Europa, no hizo nada de manera eficaz para luchar con la voluntad de Rusia, que era una voluntad de destruir el sistema desde el interior. Y eso hay que reconocerlo, decirlo y criticarlo. Y hoy en día ya no tenemos a Rusia, tenemos a Turquía y a Azerbaiyán. Y son también sumamente grandes dos dictaduras. ¿Qué hace el Consejo de Europa? Nada. Nada. Entonces, esta autocrítica también de las organizaciones internacionales, como aquí el Consejo de Europa, hay que hacerla para enfrentar el presente y el futuro. Y terminaré por la cuestión de la eficacia técnica, es decir, la no implementación de las sentencias. ¿A qué sirve una protección, una corte de protección, si las sentencias de decisión que publica cada día, cada año, no están ejecutadas? No están ejecutadas por las dictaduras, no están ejecutadas, están evitadas por los regímenes iliberales, y estas más y más de manera esporádica rechazadas por las democracias, como se llaman. Entonces, la pregunta existencial hoy en día, poniendo a la luz estos ejemplos, es ¿cómo hacer funcionar un sistema de protección dentro de una organización internacional donde la mayoría de los estados ya no están de buena fe? La buena fe, que es al centro del funcionamiento del derecho internacional, ya no está. Entonces, la ola contemporánea de rechazo de la democracia liberal, la creación y la ola de autoritaria que invade el globo, es muy preocupante porque integra también las propias organizaciones internacionales que desde el interior ya están totalmente transformadas y manejadas por las autocracias y no más de manera eficaz por las democracias. Y eso es preocupante. Gracias por la atención.
Gracias, Laurence, por la presentación muy provocativa y muy preocupante. Efectivamente, el sistema europeo ha sido un referente crucial para el sistema interamericano y otros de muchas maneras positivo, y haber visto los procesos de consolidación de la Convención Europea a través de sus protocolos y demás, fue supremamente importante para inducir cambios positivos en el sistema interamericano. De la misma manera, puede también empezar a ser un referente para que empiecen a entrar cambios negativos, y creo que ese es un aspecto que tenemos que tener muy en cuenta en estas conversaciones. Muchas gracias otra vez. Pasamos ahora para la profesora Gloria Gaggioli. Bienvenida, Gloria. Welcome. I'm going to switch to English. Welcome, Gloria. Professor Gloria Gaggioli is a full professor of international law and vice dean at the law faculty of the University of Geneva. She serves on the boards of the Geneva Call and the International Committee of the Red Cross. Her publications span various areas of public international law, with a particular focus on international humanitarian law, human rights law, and counterterrorism. She has taught and conducted research at the universities in Denmark, in France, Sweden, Switzerland, and the United States. From August 2020 to August 2024, she served as director of the Geneva Academy of International Humanitarian Law and Human Rights. Previously, she worked as legal advisor to the legal division of the International Committee of the Red Cross between 2011 and 2014. Gloria, you have the floor.
Thank you very much. It's a great pleasure to be here. It's my first time here at this university in Washington, D.C., so I feel very privileged to be on such a panel and after such a beautiful presentation. Thank you so much. So what I'm going to do in my presentation is that I'm going to focus on the human rights system at the universal level and try to see what are the challenges this system is facing. I have structured my presentation around three sections. The first one is about the human rights system at the universal level and its strengths. So I will start with positive aspects, trying to see what we've been able to achieve so far. Second, I will have a look at the challenges that the system is facing, including the crisis of multilateralism. And third, I will talk about the need for resilience and also the role that academia can play in this need for reforms. So first, the human rights system and its strengths. I think we should recall that we have been able to achieve a lot. I mean, the human rights law did not even exist before 1945. And when we see the system that we have put in place, it's quite impressive and unprecedented. So we have already a number of treaty bodies, 9 treaty bodies monitoring universal human rights treaties with vast competences. As you know very well, they are able to receive reports regularly from states. They provide concluding observations, general comments on the treaty provisions. Most of them are able to receive individual communications. Some of them do country visits. And thanks to such mechanisms and to the fact that these bodies have been able to provide really evolutionary interpretations of human rights treaties, we've been able to achieve a lot. I mean, in terms of migration, in terms of climate, environment, in terms of issues related to foreign fighters who are wanting to return home. This is not only, the universal human rights system is not only about treaty bodies, but also charter-based bodies. Now with the Human Rights Council, which has been created in 2006 to succeed to the UN Human Rights Commission, we have had the opportunity to develop the Universal Periodic Review with an objective of avoiding politicization. As we shall see, well, it's not entirely the fact now, quite the opposite, but there was this intention to remove these double standards for which the human rights, the UN Human Rights Commission was very much criticized. The Human Rights Council has been able to set up a number of special procedure at the country level, thematic levels. You have numerous special rapporteurs, working groups working on new challenges pertaining to human rights law. Another thing that I find particularly interesting is the fact that the Human Rights Council has been able to develop various commissions of inquiry in relation to armed conflict situations. For instance, in relation to Syria, Ukraine, South Sudan, Ethiopia, the occupied Palestinian territories. What I found striking is that when in New York at the Security Council, you had blockages because also of the misuse of the veto power by the permanent members and the inability really of the Security Council to react to these crises and to these armed conflicts. At the same time, in Geneva, the Human Rights Council was able to set up these mechanisms of inquiry. And so this is a big victory. I mean, the Human Rights Council is filling a gap in terms of security and in terms of collecting data about armed conflict situations. So the Human Rights Council has also been able to do things that international humanitarian law has not been able to do. As we all know, under international humanitarian law, we have very strong rules, universal rules. But at the same time, the Achilles heel of international humanitarian law is implementation, the monitoring mechanisms. And despite the fact that additional Protocol 1 to the Geneva Conventions has created the International Humanitarian Fact-Finding Commission that is seated in Bern, in Switzerland, this commission was never asked to play a role in an armed conflict situation, because belligerent parties never asked this commission to investigate. So this is why Professor Karlshoven talked about the sleeping beauty of the International Humanitarian Fact-Finding Commission. So you can imagine that under IHL, we've never been able to set up commissions of inquiry, and the Human Rights Council has been able to do so. True, all these mechanisms I'm talking about at the universal level are non-binding mechanisms. They can only issue recommendations, views. However, such bodies, the treaty bodies, the Human Rights Council, rely on treaties that are themselves binding, and their assessment has a particularly important legal value. Think about the treaty bodies. They were created by states to monitor a specific treaty. So who else can provide an appropriate interpretation and application of those treaties? Also, the mere absence of immediate sanction in cases where violations have been identified is, in my view, less problematic than one might think. Let's talk about the decisions of the European Court of Human Rights. These are binding decisions, and nevertheless, law-abiding countries, even like my country, Switzerland, does not want to implement certain of the decisions of the European Court of Human Rights, and they don't. Switzerland. Let's talk about the ICJ, the World Court. Even the World Court, take the basic case of Nicaragua versus the United States. Was the decision of the court implemented by the US? No. And still, we would all admit that the Nicaragua case is the very important case, one of the very important cases of the ICJ. So I think that we are giving too much importance to this difference between recommendations and binding decisions. In other words, the impact of the work of human rights bodies cannot simply be measured by the bindingness or rather absence thereof of their recommendations. Human rights practice at the universal level has prompted significant changes in domestic laws. The work of human rights bodies is also used to shape policies of states. I mean, we know that Turkey wants to join the European Union. One of the reasons why this is not possible so far is because Turkey has not a human rights record that is perfect or good enough. Last but not least, the human rights system at the universal level offers different fora to states to address human rights violations. In other words, it organizes multilateralism in the area of human rights. And this is not a given. These fora perform various functions. First, you have more transparency. We know about the violations that are occurring. This is also important in terms of memory, in terms of accessing the information. It allows also having open discussions, the famous constructive dialogue amongst states, amongst peers. So states have to explain their positions in front of the Human Rights Council, their practices, they have to share their opinions. And therefore, it's also a way to make customary law evolve, because you have this possibility of hearing about the opinio juris of states and looking at the practice. These fora also ensure a certain reactivity. The UN human rights system is flexible enough to be able to react to crises when they occur in a flexible manner, and to address also new challenges. For instance, talking about the neurotechnologies on human rights law, or having a progressive recognition of the right to a safe environment. The system allows really the development of the law. In the human rights sphere, we still have the possibility to have new treaties being adopted. I know that in front of human rights specialists, this might sound, basic. Commissioner for Human Rights. So many projects have been shut down, others have been scaled back. And the High Commissioner, Volker Turk, has shared his concerns about this very serious situation. In Geneva, we are hearing about the potentiality of staff relocations from the Office of the High Commissioner of Human Rights, therefore endangering Geneva as a key center for human rights at the universal level, endangering the ecosystem, and the fact that Geneva can be a kind of contre-pouvoir to the UN's political centers of gravity, particularly in New York. So I think that we can all agree that there is a need for reforms. There is a need to be resilient. There is a need to be cost effective, but destroying what we have without proposing anything else is self-defeating and leading to anarchy. And in my view, no state has an interest in destroying what states themselves have been able to achieve over time. I thank you for your attention.
Gloria, thank you very much. Another fascinating presentation that takes us again when we are thinking about the regional systems and we are thinking about the Inter-American system. Many of us here as a reference, you brought some very fascinating ideas regarding the challenges, regarding burden that exists in the backlog of cases, which is one of the biggest problems of the Inter-American system. On the other hand, on the financial edge, appears to be less of a problem. It's a big paradox of the Inter-American system. Talking with some of the UN colleagues, saying there's a huge crisis in the UN, but in the Inter-American system, in the last 5 years, the system has moved to give more money to Inter-American Commission and Court. So we have some questions, of course, of what would that mean regarding other ways in which the states may be reacting regarding this region. So I think it opens very interesting aspects of discussion. And then your reference, of course, to the importance of measuring these international regimes, not maybe only on the perspective of implementation and level of implementation of decisions, but also the impact that it may have, even if the implementation levels are low. And that's a reality in the case of the Inter-American human rights system, in which we see, very limited implementation in some cases, but maybe larger impact in the domestic system. So very interestingly, I think it opens some avenues of discussion. Thank you very much again for the provocative conversation. And now we move to present Professor Elizabeth Salmon. La presentaré en español. La profesora Elizabeth Salmon es doctora en Derecho Internacional por la Universidad de Sevilla y profesora principal de Derecho Internacional en la Pontificia Universidad Católica del Perú. Es relator especial de Naciones Unidas sobre la situación de los derechos humanos en la República Popular Democrática de Corea. Asimismo, es jurista experta y experta extranjera para actuar como amicus curiae en la Jurisdicción Especial para la Paz, JEP, en Colombia. Es autora de varias publicaciones en Derecho Internacional Público, Derecho Internacional de los Derechos Humanos, Derecho Penal Internacional, Derecho Internacional Humanitario y Justicia Transicional. Ha sido directora ejecutiva del Instituto de Democracia y Derechos Humanos de la misma universidad, el IDEPUC, directora de la Maestría de Derechos Humanos en la Pontificia Universidad Católica de Perú, miembro del Comité Asesor del Consejo de Derechos Humanos de Naciones Unidas, consultora en los Ministerios de Justicia y Defensa del Perú, así como de la Comisión de la Verdad y Reconciliación peruana, de las Naciones Unidas y del Comité Internacional de la Cruz Roja. Además, es profesora visitante y dicta cursos especializados en diversas universidades. Sin más, Elizabeth, tienes la palabra.
Muchísimas gracias, Diego, por esta invitación. Yo he dado cursos para este seminario de verano online en plena pandemia, donde fue todo un reto, la verdad, y es la primera vez que estoy aquí en persona, así que también comparto con Gloria esa sensación de estar por vez primera y ver a la gente, conversar, oír y no ver una pantalla lejana. me ha parecido extremadamente interesante tanto la posición de Laurence como la de Gloria, y estoy segura también que la del profesor Pocar. A mí se me ha solicitado hacer una comunicación, una presentación sobre, perdonen que quiero poner el cronómetro, ya, sobre mi papel como relatora especial de Naciones Unidas para los Derechos Humanos en Corea del Norte o en DPRK, la República Popular Democrática de Corea. Quiero decirles que DPRK creo que es un buen ejemplo de todo esto que estamos hablando, porque DPRK creo que pone al sistema de Naciones Unidas contra la pared. Pone al límite el sistema. Todo lo que se podría hacer contra el sistema lo hace Corea del Norte, pero no lo hace solo, sino que lo hace acompañado con como decía Ucrania la semana pasada en una reunión de la Asamblea General. No me gusta esta expresión, pero me llamó la atención que se volviera a usar con una suerte de un eje del mal que apoya cada vez más, de manera más ruidosa, notoria, con argumentos que parecían un poco atrasados en el debate jurídico, como es la soberanía, la no intervención, el doble rasero, en fin, varias de las cosas que se han dicho acá y que utiliza profusamente Corea del Norte. Entonces, yo lo que quisiera decir en estos minutos, y quiero decirles también que para mí, como profesora peruana y latinoamericana, es todo un reto tocar este tema. Yo fui impulsada, motivada también por la G-Qual Campaign, no está por aquí Claudia, pero en el marco del comité asesor trabajé intensamente con ellas, y entonces yo soy la primera relatora mujer latinoamericana viendo el tema de Corea del Norte. Tendría mucho que decir sobre eso, todos los estereotipos de género, todos los estereotipos también que hay con las mujeres latinas. Les garantizo que he pasado de la lectura a la realidad directa y creo que está siendo todo un proceso de aprendizaje. Por eso cuando tú hablabas, Gloria, de este rol de la academia, yo creo que por supuesto tenemos un rol de la academia tremendo, pero creo que también tenemos una responsabilidad de asumir nuevos retos y de poder acercarnos al mundo de la práctica. Bien, entonces, primera idea, Corea del Norte pone al límite al sistema en todo lo que se puedan imaginar. Segunda idea, sin embargo, y este es mi punto, Corea del Norte, como miembro de Naciones Unidas, la República Popular Democrática de Corea, como miembro de las Naciones Unidas, tiene la obligación de cooperar con Naciones Unidas. Y dentro de Naciones Unidas, con el sistema de derechos humanos de Naciones Unidas, tanto el convencional, los treaty bodies, como el sistema no convencional, que son los procedimientos especiales. ¿Cumple Corea del Norte con esa obligación? Creo que hay dos respuestas. Una respuesta sería desde una perspectiva de eficacia, de legitimidad. La respuesta sería no. No lo hace, no acepta el mandato que se creó en el 2004. Ninguno de mis predecesores ha tenido acceso a Corea del Norte, yo tampoco, por supuesto. Y, en fin, pone de diversa manera, se niega a cumplir diversas obligaciones en el marco de Naciones Unidas. Pero yo esta mañana quisiera, bueno, ya tarde, quisiera plantearles algunos ejemplos de cómo incluso un Estado como la República Popular Democrática de Corea coopera con el sistema. Y no lo hago para tener una visión facilista o exitosa del sistema internacional, porque no creo que sea ese el motivo que nos ha convocado a esta mesa. Creo que somos plenamente conscientes de las dificultades. Pero yo quería traer este ejemplo para que ustedes vieran cómo, a pesar de toda la narrativa contraria al sistema internacional, Corea del Norte cumple con algunas de sus obligaciones. En primer lugar, se ha mencionado, por ejemplo, el examen periódico universal, el Universal Periodic Review. Corea del Norte ha pasado por 4 ciclos del examen periódico universal. El último fue en noviembre del 2024. Y este año, al final del año, ha aceptado casi el 45% de las recomendaciones que le han hecho diversos estados. Esto me parece importante porque ahora tenemos una agenda de trabajo con Corea del Norte para buscar la implementación de esas recomendaciones que ha aceptado Corea del Norte. Corea del Norte es parte de 5 tratados internacionales sobre derechos humanos el Pacto Internacional de Derechos Civiles y Políticos, el de Derechos Económicos, Sociales y Culturales, el de mujer, que es algo que yo he utilizado muchísimo en estos años, el tema de niños y el tema de discapacidad. De hecho, la única relatora en toda la historia de las Naciones Unidas que fue invitada a Corea del Norte fue una mujer latinoamericana, Catalina de Bandas, que era en ese momento la relatora especial sobre temas de los derechos de las personas con discapacidad. Y fue recibida por todo lo alto, muy criticada por muchos, muy aplaudida por otros. Pero es cierto que fue. Ahora, en agosto de este año, o sea, en unos meses, Corea del Norte le toca presentar su informe frente al Comité de Personas con Discapacidad. Y es también allí una oportunidad para la sociedad civil, para los diferentes actores, de poder presionar para conseguir una agenda. Naciones Unidas. Naciones Unidas ha hecho casi todo lo que ha podido con Corea del Norte. Ha tenido una comisión de investigación, Commission of Inquiry, en 2014, que dijo que en Corea del Norte se cometían crímenes de lesa humanidad y que era una situación que no tenía paralelo en la comunidad internacional. Yo no voy a entrar a ejemplos, creo que todos los conocemos, pero ciertamente es un viaje quizá no tan geográfico, sino más bien en el tiempo, cuando uno ingresa a ver los temas de Corea del Norte. Ha habido como 7 sesiones del Consejo de Seguridad Públicas en Nueva York sobre el tema de derechos humanos y amenaza a la paz en Corea del Norte. Yo he participado en 2 de ellas, informando al Consejo de Seguridad. La semana pasada, en Nueva York, hubo la primera vez que la Asamblea General analizó el tema del Corea del Norte y el tema de los derechos humanos en Corea del Norte. Estaba allí, está en el UN Web TV y creo que más dentro de lo que puede hacer el sistema, hay poco que queda por hacer. Por eso digo que es un sistema que está puesto al límite. En tercer lugar, creo que este contexto de polarización extremo que vivimos, donde ya no importa qué dice alguien, sino quién dice tal cosa, creo que en este contexto de polarización, esta crisis de Naciones Unidas, que no es solo financiera, quiero decir, es en múltiples aspectos, también enfrenta estas dificultades en un momento de debilidad. Creo que el hecho de que se sepa hoy en día que soldados norcoreanos ayudan a la Federación Rusa en la guerra con Ucrania, que están desplegados en el terreno, que cerca del 40% del armamento que tienen proviene de Corea del Norte. Y bueno, ustedes no sé si vieron que había 2 soldados norcoreanos que fueron presentados a la prensa, violando el convenio 3 de Ginebra, y todo esto ha hecho que haya un renovado interés en el tema de Corea del Norte. Pero aún así, yo creo que el sistema está al límite y está en un momento de debilidad. Y además, no se ha mencionado en esta mesa, me parece a mí tremendamente importante en esta discusión el rol de la sociedad civil. Yo creo que los mecanismos de Naciones Unidas, los mecanismos regionales en el sistema interamericano, tenemos múltiples ejemplos de esto, no serían lo que son sin el apoyo de la sociedad civil. Y cuando digo sociedad civil, no digo solamente ONGs clásicas, sino también la academia, sino también las clínicas jurídicas, sino también los grupos de gente que firma, que apoya, que denuncia. En este momento también la sociedad civil está en crisis y creo que hay que mencionarlo. El tema del recorte de apoyo financiero a diversas organizaciones de la sociedad civil ha generado una crisis alrededor de la situación de derechos humanos en Corea del Norte. Lo bueno es que se ha puesto al descubierto cómo el donante parecía que era uno y no varios, pero en realidad múltiples organizaciones de la sociedad civil, asociaciones de víctimas, etcétera, los que se llaman escapees, las personas que han huido de Corea del Norte, están ahora sin la posibilidad de ejercer una acción fuerte y coordinada en materia de derechos humanos. Entonces, yo he querido compartir esta pequeña experiencia con ustedes porque creo que podemos teorizar mucho acerca del sistema internacional de derechos humanos, pero yo creo que a pesar de todos los retos que para mí supone el caso de Corea del Norte, vemos un sistema que requiere resiliencia, pero que también requiere involucramiento de diversos actores y que también requiere una acción política alrededor del sistema. Creo que la academia también tiene que cumplir ese rol, ustedes como estudiantes también tienen que cumplir ese rol, porque no es, como decía Gloria, algo que está allí y siempre va a estar allí. Yo creo que hasta ahora el sistema está resistiendo, lo veo en esta lucha con Corea del Norte. Creo que Corea del Norte coopera, pero es una cooperación pick and choose. Decide en qué cooperar y decide en qué no cooperar. Quizá superficial, como decías, quizá más formal que real, y con eso concluyo, pero creo que es importante ver que el sistema todavía tiene herramientas para funcionar. Gracias.
Muchísimas gracias. Muchas gracias, Elizabeth, por la presentación y creo que trae un par de aspectos a la conversación muy importantes. El primero de ellos es el importantísimo rol del multilateralismo para traer actores, inclusive los más recalcitrantes, a la mesa, para sentarlos a hablar en clave de derechos, en clave inclusive legal. Y yo creo que ese es un punto muy importante de lo que se ha logrado, uno de los logros de toda la arquitectura, como se ha mencionado antes, en derecho internacional de los derechos humanos. Cuando hablamos del multilateralismo es precisamente eso, poder traerlos a la mesa y poder conversar en ese tono. Y por supuesto, nuevamente, las referencias al sistema interamericano, que estamos nuevamente pensando nosotros, la importancia, qué se ha logrado y cuáles son los retos. Efectivamente, uno de los logros ha sido el de lograr traer inclusive a los actores más recalcitrantes en muchas circunstancias a conversar. El problema es cuando los actores abandonan la mesa, que lo estamos viendo en el sistema interamericano, y yo creo que ese es uno de los retos más dramáticos, no solo del sistema interamericano, sino por supuesto sistema europeo, Naciones Unidas, que vamos a tener que abordar en los próximos años. Muchas gracias otra vez. Paso nuevamente al inglés para presentar a nuestro panelista, nuestro último panelista, last but not least, Fausto. Thank you very much for being here. Professor Fausto Pocar is Professor Emeritus at the University of Milan, ad hoc judge of the International Court of Justice and former president of the International Criminal Tribunal for the former Yugoslavia. He was the International Criminal Tribunal's president from 2005 to 2008. He had previously served as vice president between 2003 and 2005. Judge Pocar began to serve as a tribunal judge in 2000 and was re-elected twice by the UN General Assembly in 2001 and 2005. He is professor of international law in the law faculty of the University of Milan, where he has also served as dean of the Faculty of Political Science and as a vice rector. He is the author of numerous publications on international law, including human rights and humanitarian law, private international law, and European law. He has a long-standing experience in UN activities, in particular in the field of human rights and humanitarian law. He served 16 years as member of the Human Rights Committee under the International Covenant on Civil and Political Rights in 1984 to 2000, and was its chairman between 1991 and 1992 and rapporteur in 89 and 90. Professor Pocar, the floor is yours.
Thank you. Sorry. It's okay.
Yeah, there it's correct.
Thank you, Diego, for giving me the floor. As the last speaker in this panel, and I must say it's after hearing all my colleagues, it's not very easy to take the floor because they put so many issues, raise so many issues that I will not comment on them at all. But nevertheless, I may not resist not to comment to some. Let me say in general that the problem of the crisis of multilateralism is important and cannot be linked too much to human rights in a way. Of course, the crisis, the human rights problem has become a main issue in international relations after the Second World War. And in any crisis, it comes to consideration by the participants, by the international community, inevitably, because it touches directly the individuals and the people are concerned. On that matter, my feeling is that the international community, irrespective of the human rights problem, suffers of a crisis which impacts on human rights inevitably, but is a crisis of legitimacy of the international institutions. And that's the basis of the problem, actually, because historically, it's obvious in a way. The international life has gone through periods of aggregation and periods of disgregation. That was always the case. When international law, modern international law, as we consider it, started in the 17th century, started after a long war. It started changing the system that was based on authorities, high authorities, to which the states were linked and had to obey in a way, depended on the Pope and the Emperor. The system changed, states became independent, and the principle, the basic principle, was the coexistence of the states, not the cooperation of the states. At the beginning, they did not cooperate. They lived until they had other wars to resolve the problems between them. And they started to cooperate at that time. It was after the Council of Vienna in the 1815, after the Napoleonic Wars. This system that was adopted there was based on the great power of Europe, because at that time there was not yet the problem of the new countries that were colonies, essentially. Most of the world were colonies, or did not participate in international life to a certain extent. So this system worked for 1 century, essentially. And then we had the First World War. Then there was an attempt to define better an organization of the world. It was not done well, probably, and we had the Second War. The Second War established a new order. That order is having a crisis after 8 years, which is normal in a way. It's normally what happens in international life. And we have the impression that the world is coming back to a situation before, going from a system of cooperation to a system of non-cooperation, which is based on sovereignty, essentially on sovereignty. And this is a problem of all the institutions, universal, but mainly also non-universal, regional. What we heard of the initiative of Denmark and Italy is clearly a problem internal of the European system. The legitimacy of having a court which decides which is what will be the states of the... And I have the impression that there is a lot of problem linked to steps that have been done to have judicial institutions. Judicial institutions, if you have a fragmented world, do not work, cannot work. And you have to go for different approaches. And what Gloria told us of the still working system in human rights, a bit less maybe in IHL, but in human rights certainly, is because the system of work of human rights institutions is compatible with a society which is based on sovereign states, independent one from the other. That's my feeling. Korea, imagine what happened during the Cold War. The human rights institutions were working perfectly well. They did a lot of work notwithstanding the Cold War. but could work because they didn't have binding decisions. They were patient. They were raising issues. They were discussing, having conversations with the states, and progressed, nevertheless, notwithstanding the Cold War. The case of North Korea, I remember when I was in the Human Rights Committee, it happened that the government of North Korea denounced the Covenant on Civil and Political Rights. Now, the Covenant cannot be denounced, according at least of the position of human rights bodies, and especially of the Committee of Human Rights. What did the committee? Wrote a general comment on the impossibility of denouncing the Covenant, and stopped there. What happened? North Korea, 1 year or two, didn't send a report, the periodic report, but then started sending the report. But we didn't make any strong statement against. We made a general comment, just legal, saying that it cannot be, but without referring to the situation. And that's why if you don't have binding decision, you need patience in these things. And the international community is becoming that. But there is the problem with the legitimacy of the United Nations. And that's a real problem. The system of the United Nations was decided in 1945. And it was a good system based on a community of around 50 states. Limited. Now the states are 193. But the powers in the UN are the same. No change at all. It's true, new countries have emerged. The colonization has been dropped to a large extent. Has it been dropped completely in substance? It's not true. There are still many countries that are decolonized now. There are new countries, but they are not, don't have this, they have a vote in the General Assembly. Well, that's it. And the General Assembly doesn't have any power. That we know also. The power resides in the Security Council. So either we, the big states accept and recognize that they will lose at the end if not reforming the system, or we go to wars inevitably. Because when a community is based on independent states without any system for composing the difficulties, the settlement of disputes, you can say settlement dispute has to be made by International Court of Justice. But then when you go to the International Court of Justice, the International Court of Justice itself is very careful in dictating the law, and they recognize the law, makes a lot of compromises. And if you look at the decisions of the court, they make a lot of compromises also in law, not only on the facts, but on the law. And why they do that? Because the court is based on the agreement of the parties. There is no decision of the court if there is no agreement between the parties to go to the court. So we go back to the old system of arbitration, essentially, where the parties have to accept the jurisdiction of the court. And it's normal if the global institutions are weak and considered not legitimate by too many. What happens, what may happen now, you have other groups creating alternatives to the Security Council. Not completely, not completely, but there is this system that's growing. Will it serve to base shaping a new system for the world? I'm not sure. I think it's if one looked at the history, you would need a war to make a settlement. I hope this will not be the case, but I'm concerned about that.
Yeah.
I stop here for the moment. I'm sorry to put this out.
Thank you very much. Fausto, thank you very much for reminding us the long process of consolidation of international, contemporary international public law in general, of international institutions, and more specifically, what we had to go through at the beginning of the 20th century. You know, 2 wars, horrible wars, humanitarian catastrophe, and reminding us that, you know, multilateralism to a certain extent is the word that opposes war. That's the cliff that we are looking at if we are beginning to undermine the system, the overall system of multilateralism beyond, as you were saying, human rights mechanisms. But in the specific case of international human rights law and international human rights mechanisms has special significance in the sense that it now engages, as you were saying before, Elizabeth, civil society. It's much more engaged, which it was not true in other traditional, more traditional public international law institutions, in which it was a real conversation among states, but civil society was deprived or very much in the outskirts of the conversation. And I do believe human rights law, to a certain extent, has given that extra step of linking civil society, you know, other actors beyond states to the conversation. Hopefully, that can help a little bit to ensure as a guarantor of this international governance system. Maybe beginning from the human rights world, because we have, you know, other actors engaged, and not only NGOs, but you have law firms, you have academia, you have many actors that are now seeing the benefits of this. And hopefully, as you were all calling for academia to play a role, hopefully we can play that role, and you can all play that role regarding facing what we are seeing in the horizon, you know, a very severe threat to multilateralism. So thank you again for all of you for the presentations. Now, I think we can open the floor for a few questions for our panelists or comments. So we can begin. You can give Gabriel the microphone maybe to the speakers, and we can begin here. We can pick up, you know, 2 or 3 questions and deal with them.
Hello. J'ai une question pour Laurence. Regarding, you mentioned very briefly the appreciation margin, that it has been, the notion that has been used by the European Court of Human Rights. How can we, and it has more recently been used also very vaguely by the Inter-American Commission and Court of Human Rights. How can we balance this notion of appreciation margin, which I understand it's sort of linked to the multilateralism notion of, but also with the protection of human rights. Thank you.
Please identify yourself. Yeah.
Oh, hello everyone. I'm Tatiana Vances. I'm an Argentinian human rights lawyer, and I just finished my LLM in human rights and humanitarian law.
Thank you.
Hi everyone, thank you very much for your speech. My name is Dilshad. I am from Kyrgyzstan, but I'm ethnic Uyghur. My grandparents came from China in 1960. My question to you, Professor, what do you think, like, still happening violation of human rights in China? So does the world need to create stronger actions against China, like adopt new law, like, I mean, international legislation or something like sanctions against China? So, and second question for you, Professor, what do you think about ICC? Can they take case against Palestine? And can they I mean, like, what is the legal barrier or the political barrier for this action? Thank you.
Thank you very much. A third question, Gabriel?
Yeah, there's one online, sorry.
Exactly.
There's one online. So I'm going to read the question in Spanish because it was drafted in Spanish for everyone. And this question is, esta pregunta es de Giovanni Padoan. Y él está preguntando, el reciente ejemplo de la suspensión de fondos en Estados Unidos mostró el nivel de poder que las donaciones voluntarias, no necesariamente el presupuesto regular, tienen la financiación de los organismos internacionales y asimismo en su manejo para intentar dictar cierta línea de conducta de los organismos internacionales. ¿Cuáles serían las alternativas para un tipo de financiación más sostenible y menos dependiente de estos tipos de donaciones, súper concentradas en ciertos países?
Okay, so we can take those questions and if I may, we can use the same order that we began the presentations and you can choose the questions that you want to refer. So if you go ahead.
Vale. Bueno, el oído de tu pregunta no tenía bien los oídos abiertos, entonces, pero si te he entendido bien, tu pregunta trata del margen nacional de apreciación, su uso por la Corte Europea y cómo usar esta teoría con qué exactamente.
¿Cómo puede afectar al marco de protección de los derechos humanos?
Vale.
Pero teniendo en cuenta que es una noción que se está expandiendo a otros sistemas más allá.
Vale. Si el margen nacional de apreciación es una creación pretoriana del Tribunal Europeo de los Derechos Humanos, que al principio se ha creado en un ámbito muy específico, la voluntad por un Estado de crear un estado de excepción. Entonces, en este ámbito muy específico, la Corte ha dicho, ok, si un Estado quiere poner en marcha un estado de excepción, porque una guerra, un terrorismo, se puede, pero se necesita al final un control. Esta teoría, creada en un ámbito, en un contexto muy específico, se ha efectivamente expandido para todo tipo de contexto. Deja efectivamente una capacidad para el Estado de restringir como, entre comillas, le da la gana los derechos protegidos. Eso no quiere decir que no haya un control convencional, pero el control convencional es mucho más restringido. Entonces, la capacidad de los estados de restringir los derechos es más amplia y el control convencional mínimo. Claro, en este contexto, el margen puede permitir más afecto a los derechos. Sobre todo lo que hay que entender es que más y más hoy en día esta noción está utilizada por la Corte con otro tipo de interpretación diferente, porque se trata de eso, la diferencia a los estados para que ellos se sienten más libres, ¿no? Porque el derecho y el derecho internacional está visto como algo que no le permita ser libre. Esta teoría está más y más utilizada con lo que se llama el Process-Based Review y trata exactamente de lo que unos de vosotros han hablado, es decir, la idea de mantener la soberanía. Hoy en día los estados quieren reapropiarse su soberanía. Y el Process-Based Review, ¿qué es esto? Es la idea de si una ley está bien adoptada democráticamente, con todos los contrapesos internos. La Corte Europea ha dicho, mi control va a ser súper mínimo, porque es un parlamento democrático que ha adoptado la ley y en este contexto tengo que decir yo, Corte Europea, que el centro nevrálgico de una democracia es el Parlamento. Entonces, todo esto tiene que ver también con una voluntad de los estados soberanos de retomar su soberanía, pero más allá, su sistema democrático. Siendo dicho esto, el sistema democrático se basa o en el pueblo, referéndum, o en asambleas nacionales que tienen el corazón democrático. Esta idea ha sido muy fuerte en la sentencia reciente del 9 de abril de 2024 en el asunto climático. Por primera vez en su historia, es muy llamativo eso, la Corte Europea ha presentado de manera casi in abstracto unas líneas muy fuertes diciendo, aquí le voy a explicar dónde se sitúa mi control convencional. Y delante de las críticas más y más fuertes viniéndole de los estados, la Corte ha dicho, estoy muy consciente que todo juez, es decir, el juez nacional como el juez internacional, tiene un poder muy limitado. Después de la voluntad democrática soberana exprimida en un parlamento. Entonces, la Corte ha dicho, sé que el pulmón democrático no se encuentra en las manos del juez, se encuentra en las manos de las asambleas legislativas o del pueblo. Pero eso es sumamente fuerte eso, ¿eh? Es una manera de contestar a los ataques diciendo que la democracia está limitada por este control internacional. Pero afortunadamente la Corte Europea ha añadido otra cosa. Pero sí, cuando el pueblo o sus representantes ya no caben con las líneas de protección de la Convención, sí, ahora mi control, viene el control del juez nacional como el control de la Corte Europea, pero será un control mínimo, será un control subsidiario, será un control final que tiene que respetar de antemano este nivel democrático. Entonces, la propia Corte Europea ha presentado como un vademecum democrático, recordando a los estados que se quejan muy fuertemente, que estoy muy consciente cómo una democracia funciona. Y ha hablado de las separaciones de poderes y todo esto. Entonces, se puede criticar esto, se puede criticar el margen nacional de apreciación cuando no está bien utilizado, se puede criticar este vademecum democrático diciendo, pero ¿para qué el control convencional? Pero tenemos también que entender, es decir, soy la pesimista, creo, de la mesa, quizás es mi onda actual, ¿no? Pero creo que nosotros todos, sociedad civil, academia, nosotros todos tenemos para pensar la reacción, pensar la contraofensiva, tenemos que entender absolutamente, perfectamente, por qué eso, de dónde viene este rechazo, por qué este rechazo, si no, nuestras estrategias no van a funcionar, ¿eh? No van a funcionar más, porque como lo ha dicho Fausto Pocar, el mundo ha totalmente cambiado y la legitimidad de todo ese sistema internacional, universal, regional, ya está totalmente atacado usando un argumento muy fuerte, el argumento democrático. Entonces, sí, eso tenemos que entenderlo, comprenderlo, para pensar bien la contraofensiva.
Muchas gracias, Gloria.
Thank you very much for your question. Not an easy one, right? Because we don't see many different paths. I mean, if we look at the Security Council, we know that there is no hope for sanctions adopted by the Security Council since China is a permanent member. So there is a no-go. With the Human Rights Council, I think it was a huge missed opportunity to at least have a discussion. So I'm not saying that the discussion is going to change things in the field, in the country immediately, but at least having other states taking a position on that. So it was a huge missed opportunity. At the same time, treaty bodies can continue having an engagement with China. That is totally possible. And then we can think of different states engaging even behind closed doors. Sometimes you can obtain even more behind closed doors, having a solid engagement with the states, putting certain conditions for certain, contractual, let's say under the trade, to avoid certain contracts, saying, well, if we don't have an improvement in such situation, then we are not going to continue trading in this area or that area. So, I mean, there are those means. And in addition to that, we mentioned the civil society, and I think the civil society can play also a very important role, at least in terms of making the violations known. But of course, there is no easy solution to that. And we see that there is a kind of double standard that remains when powerful states commit very serious violations. Even if we can try to do as much as we want, in the end, the implementation is not as solid as we might wish. So sorry to not have a magic solution to this, obviously. Regarding the funding crisis, I think it's very interesting, this idea to try to find other solutions, not relying only on states to fund the human rights system. And I think we did not pay sufficient attention to this. And probably this financial crisis will oblige us to try to find other models for financing also the human rights system. So I don't know, we could think about even the private sector. I mean, I don't know, but I think it's a great question that would need really a further research. So thank you for that question. I think perhaps to link it to finances, I think the human rights, the belief in human rights law is transcending institutions. And so even if we are going backwards, the society has changed. The people have changed. So if institutions are blocked, I know we are going to find other solutions. And I'm not sure that it will mean that states will be better off. Because in the institutions as they exist, states are extremely influential. They determine the rules of the game. If the institutions are blocked or do not function, other things will pop up where states will have less influence. So I think that we are at a tipping point, and states cannot simply say, well, we are off or we don't want to cooperate. Because if they do so, then we are going to have something else and they will lose more than anything. So I don't know what's going to happen, but I'm sure that the civil society, academia, think tanks, everyone, private sector will try to build up new things if we have empty rooms. It's not the case yet, but it is true that the financial crisis is particularly problematic because you can have all the beautiful ideas. If states stop from one day to the next financing the human rights system, then what do? We see already now that the treaty bodies often cannot meet in person, that they are having video conferences. But, is it the same? Not really. It's not the same. So this financial aspect is quite crucial. Thanks.
Thank you very much, Gloria. Please, Elizabeth, you have the floor.
Muy brevemente, yo creo que aquí sobre la mesa hay una discusión que es vital. Es que queremos que los estados sigan en las organizaciones internacionales, por ejemplo, en temas de derechos humanos, o es que se va a permitir que salgan. Creo que la pregunta aquí es cuál es el costo de continuar con esa participación estatal. ¿Hasta qué punto el sistema se va a desconfigurar completamente para poder mantenerlos dentro? Entonces, creo que esa es la reflexión que hay que hacer, hasta dónde se llega. Por ejemplo, este tema del argumento democrático, ¿no? Es un tema tremendo, es un tema tremendo. Me hace pensar en el caso Hellman contra Uruguay, donde más bien la idea era que no todo podía ser decidido por las mayorías. Y ahora más bien encontramos un sistema en que si es la mayoría, entonces yo me tengo que hablar bajito, tengo que decir poco, porque la tensión puede ser mucho mayor. Creo que este es un tema excelente, Diego, el que has planteado para esta mesa, a pesar de que dices que cada año vas a saber de crisis, pero realmente creo que es excelente y creo que es necesario reflexionar sobre el futuro que queremos para el multilateralismo y para la protección internacional de los derechos humanos.
Muchas gracias, Elizabeth. Fausto, please.
No, this one is okay.
I may have been seen as pessimistic. But in fact, I'm not. In the sense that I see the possibility of improving the situations, not only for historical things, because things are waves, they go up and down. And now we are down, but the wave may be up again. So this is may happen with humankind. The problem is that we have to keep cooperation as essential on global issues. There is no way that humanity can go on, or the world can go on, breaking everything. So there's the need, you can do without the great institution, invent something else, but you need to have an international cooperation because we are facing global problems. And you cannot resolve global problems only with a group of powers. You would not resolve pandemics, and we are having one. Experts say we are having a pandemic soon. It has to be dealt with better than the one we had before. But we have the agency of the UN for health, which is dropping down completely because it doesn't have funds. So we are really risking a lot because of that. We have the climate problem. We have other problems in the world. These problems have to be dealt by the international community. And it may have a cost. Yes. May have to be accepting certain positions that we may not like also. But it's only keeping the dialogue on, be in the UN or outside the UN, in other fora, that you can resolve these problems. And I think if we have a future, it depends on that, essentially now. And it's impossible. It's not just the traditional world. We never had these global problems. They are just emerging now. And this has to be resolved. But has to be resolved having dialogues with people even very different from us. Because on this issue, they may cooperate. Because this is the interest of everybody. This it's a question of finding the issues that are of general interest and having everybody cooperate on this issue, which makes a change, of course, in the system, but is what the human rights system was always tending to do with non-binding solutions, essentially, that the states do not feel as an imposition, actually. I look at the interesting initiative that was made in the International Law Commission of a convention on crimes against humanity. Now, the crimes against humanity is the poorest brother of the international crimes because it started with war crimes, it started with genocide, and so on. But crimes against humanity is, at the beginning, was linked to the war crimes, was a system that depended also on war crimes, but is a system that the crimes against humanity in which the idea is to go back to states, not to give them to an international court, which will have no success. It's clear the International Criminal Court will have no success. It's already dead almost. So it will not go on becoming the world court. It's not the world court, it will not be, never be. So you have to find something else and have the states cooperate again. I don't know whether the system that was adopted after the Second World War with war crimes, it didn't work because of the Cold War, the Geneva Conventions. But nowadays, It has to be revitalized, I mean. And this Convention on Crimes Against Humanity is exactly adopting the same approach of the Geneva Convention in 49, not to give these crimes to an international court like was Nuremberg or the Tribunal of the East, but have the states doing that, bring it back to the states' cooperation between them. And I spoke to many lawyers. The International Bar Association is very interested in that convention because they see a position for lawyers to work together with other lawyers on this issue of crimes against humanity. Will not be, of course, the respect for all the crimes against humanity as we consider now, but it may bring about a cooperation on these matters, which again goes to human rights. And Gloria, you spoke of the relations between the human rights system and the international humanitarian system. I see a great connection between the two systems because human rights emerged in the international community through the law of war. It was not a peaceful initiative. Human rights were brought about by the law of war. When started the movement of human rights? At the end of the second part of the 19th century, with humanitarian law, with the idea of law of humanities in war, because the main violations are there. And then it emerged also in peacetime. So we have to consider that maybe the system that was adopted in one sense may work in the other more. So it's, I see many lines, common lines there. And this, I look at this convention, that is the only part that was not, does not have a system based on states. It's the only part of the international criminal law. So I'm optimistic that there are initiatives that may go in the right direction, as I see the right direction, but the important is to keep in any case a dialogue between all the partners. There is no other way of doing it.
Well, thank you very much. We have come to the time. We have to close the panel. I'm sure there could be other questions, but really wanted to thank you for the provoking and fascinating presentations. I think I have the feeling that the genie is out of the bottle, and it's going to be very difficult to put it back. We'll see what shape it's going to take in the future to a certain extent. But again, a pleasure to be with you all. Thank you very much. Oh,
Stay sitting.
A sitting picture.
okay.
A sitting picture.